All right, good afternoon, everyone. Happy Friday, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for representing clients with disabilities. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive a copy of the recording, a link to the materials, and the CLE information via email from Zoom within 24 hours. I will also be posting it on YouTube, so you can find it on our YouTube channel as well. And the information will be in the description for the YouTube video. The training was approved by the Florida Bar for 1.5 General CLE credits, zero point 0.5 Ethics credits, and zero point 0.5 Technology credits. I'll announce the CLE code towards the end of the session. I will also drop it into the chat. You will also find the CLE code in the email that comes out from Zoom and in the YouTube description as well. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility, just let me know via chat or email. I'll drop my email in the chat as well, just in case. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I highly encourage you to take a look at their website and membership and benefits. I'll drop a link to the PILS website into the chat as well. And final piece of housekeeping announcements, if you have any questions during the presentation, feel free to either use the chat, the Q&A feature. You can also raise your hand and I can bring you off mute if you want to ask your question. So make sure to use that feature if it works for you. Make sure that if I do bring you off mute, to mute yourself afterwards so we can continue with the presentation. And with that said, those are all of my housekeeping announcements. I'm going to go ahead and introduce our amazing speakers today. First up, we have Katherine Hanson. She's an attorney with the Consumer Protection Project with Florida Legal Services. Katherine Hanson was the Director of Advocacy for Education and Outreach at Disability Rights Florida, where she focused her practice on disability rights and housing law. Our other speaker is Caitlyn Clibbon. Caitlyn is the director of the Community and Healthcare Services team at Disability Rights Florida. Her work focuses on healthcare and community inclusion, and she previously helped draft and promote Florida's supported decision-making law. Without further ado, I'm pleased to pass it over to Katherine and Caitlyn. The floor is yours.
Hi, everybody. Thanks for coming. So Jorge gave us a little bit of an introduction. I did just want to note that while I am now part of the consumer unit, my area of practice has typically been housing, specific to people with disabilities and the housing problems that they face. And I wanted Caitlyn to tell the audience a little bit about Disability Rights Florida, what it is, and why it's important that they exist. And I really encourage you to keep them in mind when you are representing clients with disabilities.
Sure, thanks. So Disability Rights Florida is Florida's protection and advocacy network. There's one of us in every state and territory. We are created by the federal government and through a variety of statutes and funding sources. And our job is laser focused on promoting and protecting the rights of individuals with disabilities. We are kind of a quasi-legal aid organization. All our services are free for our clients. Eligibility really is just based on being a person with a disability and within the scope of services we provide. We are statewide. We do representation in all sorts of areas, legal representation and also advocacy. So we, anywhere from healthcare to ADA issues, service animals, housing, education, and we also have an arm that does monitoring in various state facilities like psychiatric hospitals, the state hospitals, prisons and jails. So we're able to go into those settings and monitor them as far as the rights of people with disabilities being honored or not. And yeah, so we are here. I think hopefully at the end of the slideshow, there's some contact information. If not, we can share it out when we share out the slides. But we are always here to assist, co-counsel, consult, or just kind of, or, for referrals for individuals who may not fall under your practice areas.
So as Jorge mentioned, I was also an attorney with Disability Rights Florida for about 6 years. Our goal today is to discuss not only the law at issue, but best practices as we see them as former and current attorneys from Disability Rights Florida, the Protection Advocacy Agency, for representing people with disabilities. So you might not be surprised to learn that the bar's guidance in this area is a bit vague. So in those instances when the guidance is vague, we will offer you what we think are best practices for representing clients with disabilities. I'd also just say we could spend days on a lot of the topics that we touch on in this presentation. This is more of a general overview. Please do feel free to ask your questions during the presentation. We want to make sure that everybody is getting the most that they can out of this talk. Next slide, Caitlin. So why should you pay attention to us? Why are you here? People with disabilities make up a large proportion of the population. Lots and lots of people, including lots and lots of your clients, are people with disabilities. Note that while disability in general is relatively common, you can see on average there's going to be about 29% of the US population that has some type of disability. The number of attorneys who self-report they have a disability is about 2%. Now, there are a lot of reasons for that. One is that it's self-reporting, and there is, of course, a lot of stigma related to disability, but there are also lots of barriers to entry into the legal field and other professional fields. Those barriers are really beyond the scope of this presentation, although you should keep them in mind. Next slide. And because of those barriers, to what we call community integration, which we'll talk about in a moment, there are huge impacts on our clients. So people with disabilities are more likely than their non-disabled peers to be unemployed, to be unable to afford healthcare that they need, to have lower levels of education, less likely to go to college, less likely to have careers in professions like being a lawyer, less likely to be doctors. They're more likely to live in poverty, be unbanked and underbanked, and be food insecure. The reason that I want to bring this up now is because at the very end of the presentation, I'm going to remind you about the importance of the work that you do as legal aid and other attorneys representing people with disabilities, because you can assist them in overcoming a lot of these barriers. Next slide, Caitlin. So why are we even talking about community integration, and what in the world is that? So before I worked at Disability Rights Florida, I spent a decade at Jacksonville Legal Aid doing, legal aid housing work. And while I understood sort of the concepts of community integration, that was not a phrase that we used, and I didn't really understand its importance until I went to the P&A. So community integration for people with disabilities just means that they have the same opportunities and choices as people without disabilities in their community, and any supports that they might need to access those opportunities and choices. So how to think about that? Consider the many ways, and these are not all the ways, that people with disabilities are segregated in our society. So we have separate housing, right? You've got group homes, you have what some people might know as intentional communities, housing that's built specifically for people with disabilities. We have separate education, whether it's a separate school or simply a separate classroom within a school. And we have separate transportation, both at school and also in public transit in many places. So these are separate services and separate places, often of lower and different quality, right? So community integration is the idea of removing all of these barriers that cause people with disabilities to be separated from the rest of us. So every time you represent a client with disabilities and you keep them in their home, you help them receive an education, succeed at work, etc., you are promoting community integration. For example, if you represent a client who has a live-in aid that they need to ensure they can stay in their apartment, and you prevent eviction, you may prevent that person not just from being evicted, but from having to move into an institution like a nursing home where they can receive the disability-related care that they need. So in many of our cases, whether it's assisting someone from falling even further into poverty or being evicted, we are assisting that person in remaining integrated in their community. Next slide, Caitlin. So on to some practical stuff. So we're going to talk about disability etiquette for a while. Well, what do we mean by disability etiquette? It's simply the things that you can and should do to treat your clients with disabilities with respect, like you should any client. This means in your communications, your personal interactions, etc. Appropriate etiquette is going to vary depending on the person and their disability. For example, if you meet a client for the first time, or really meet any person, obviously you want to introduce yourself before you talk. If you're talking to a person with a speech impediment, you want to make sure that you've actually understood what they said before you proceed. So some specifics. People with disabilities are not, quote, special. We want to always avoid euphemisms related to disability. It's okay to say disability. Some people with disabilities prefer what's called person first language, which would mean you would say a person who uses a wheelchair. You identify the person first. Some people with disabilities don't prefer that. Feel free to either follow their lead in the way that they refer to themselves or simply ask them. You know, mistakes are okay. What's important is that you do your best to treat that person with respect and refer to them in the way that they prefer. It is also extremely important, and we'll focus a lot on this because of the nature of this discussion, to talk to your client, right? Don't talk to their mom, don't talk to their spouse, don't talk to the interpreter, don't talk to their aide if they have one. You want to always be looking at and speaking to your client. And like with any client, you want to use plain language and be patient to ensure that you understand what your client is telling you and to make sure you've answered their questions. These slides don't provide an exhaustive list. Like any topic, we're always learning. These are just our ideas about best practices. So when you meet a new client, and even as your representation continues, you want to ask them what kind of communication style is best for them. There's some practical ways that you can figure that out. You can just ask them. Do you prefer to talk by phone? Is email best for you? Do you need large print? Do you need to meet in person with me? Do you need an interpreter? Sometimes a client might have a little bit of trouble giving you that information, probably because no one has asked them that before. So you can be more creative. You might say, if I gave you today's, your community newspaper, how much of that do you think that you could read and understand? Because you know the reading level in that newspaper, so you can help gauge what kind of communication style that you should adopt. It's important to make sure that when you're communicating with your client, it's accessible to them, right? Not just accessible to your general person, accessible to that client. You want to make sure that you explicitly explain that you will provide accommodations that are necessary to ensure that you have effective communication with your client so you can effectively represent them as required by the rules. So if you don't already know, the ADA does apply to law offices, and you do have a legal obligation not only to provide accessible spaces, which does vary depending on the age of your building, but to provide accessible communication tools. So for example, if you are representing a client who is deaf and they require an interpreter, you must provide that interpreter for them. And there's a variety of similar types of aids and accommodations that you may need to provide, with the goal always being that your communication with that client is going to be as effective as it would be with a client without a disability. And I just want to give another reminder, not everyone has worked with a client who has an interpreter, whether it's a sign language interpreter or a different language interpreter. Always look at and speak with your client and not that interpreter. Do remember that your client is entitled to privilege, even if they have another person in the room assisting them in their representation. So for example, if a person needs an interpreter, that person is there because they're necessary to provide legal services. So that person does not break your privilege, right? That person is there because they have to be to ensure that you can communicate effectively with your client. That's different than just having your mom in the room because it makes you feel better, right? Your client might waive privilege in that instance. But keep that in mind, whether it's the interpreter or an aid that they need in order to be in the meeting with you so that you can communicate with them. That does not mean that your client is not entitled to privilege in those circumstances. And we'll talk about that a bit more in a moment. Next slide, Caitlin. So here are some basics that I think everybody should know, but I think folks sometimes are trying to be helpful and might run afoul of some of these basics. Keep your hands to yourself and your thoughts to yourself about somebody's disability. So you don't ever touch somebody's wheelchair or walker or cane or their person unless they have asked you to. So don't touch their service animal, don't attempt to push them through a door, etc. Now that is unless they asked you to, right? And we are all reasonable people. If it looks like your client is struggling with something, you can say, would you like me to help you with that? But if the answer is no, then the answer is no. People with disabilities live their lives all day without you. You need to follow their lead. Similarly, don't ask invasive questions about someone's disability if those questions are unrelated to representation. So, Caitlyn and I, in the past anyway, have only represented people with disabilities with legal problems that relate to their disability. So we would have to ask many invasive questions because it's specifically related to the matter at issue. But if it's not, then it's not your business and you should not be asking those questions. You may have heard of the phrase benevolent discrimination, which is essentially where people believe that they're being helpful by supporting a person with a disability when really they're undermining their independence and their personhood. So really take your cues from your client. It can be difficult to get used to doing that. The more people with disabilities you represent, the easier it is to just treat them like any other person. Similarly, don't assume that a person with a disability doesn't have some skill or ability that you need them to have. You should assume that they can do what you're asking them unless they tell you otherwise or unless it is clear otherwise. Next slide, Caitlyn. So practical stuff. We're going to talk a lot about powers of attorney and guardianships. So I want you to be thinking about these things early, right? If, let's say, someone calls your intake hotline or comes into your office and it's not the client, right? It's some other person. And they say, I want to talk to you about Bob. And you say, well, you're not Bob. And they say, well, I'm their power of attorney. Say, okay, cool. Still going to talk to you. One, send me a copy of the power of attorney. And as we'll talk about in a moment, you're still going to be speaking with that client. Or if it's, for example, a student or a young adult and the person who contacts you is their parent. Okay, well, that person's still an adult. Their parent is not their guardian, right? Not necessarily anyway. If they are their guardian, you're going to get a copy of that guardianship document. And then you're going to read all of the pages of those things, of those documents, right? Can you do the next slide? So you're not going to trust what someone is telling you about their position as power of attorney or as guardian, right? So like I said, if someone calls your intake line and they say they're the POA, there should not be an intake until that power of attorney is provided and that client is available to speak with you also. But when you get the power of attorney, keep in mind what the law requires. Is the power of attorney notarized? Were there two witnesses? You also want to actually read it. You want to have all of the pages of it. One, some folks want to send you the first and last page. That's not sufficient. You want to read what it says. Not every power of attorney is equal, right? It will lay out the things that it permits the person to do as the power of attorney. The case law is clear. Powers of attorney are strictly construed to grant only those powers that are specifically delineated. So you want to read the power of attorney to know what those powers are. Similar guardianship, you want to read the order of guardianship because they are also not all the same, as Caitlyn will tell you. So you want to ask for those documents up front. You want to make sure you have every single page. You want to read them in their entirety. And unless folks have any questions about what I've talked about, Caitlyn is going to jump into guardianships, guardian advocacy, powers of attorney, and supported decision making.
Yeah. So feel free to interrupt or put it in the chat if you do have questions. But like Katherine said, I'm going to talk a little bit about the differences between guardianship, guardian advocacy, powers of attorney, supported decision making, and how that affects your interactions with your client. So they're not the same thing. Guardianship and guardian advocacy are not the same thing. SDM, supported decision making, is a version of a power of attorney, but it's not the same as a durable power of attorney that many of us are familiar with. And like Katherine said, always read these documents, read the whole document and make sure you understand it. So starting with guardianship, in the kind of range of restrictiveness, a guardianship, I would say, is the most restrictive guardianship and guardian advocacy. So under guardianship, a person gives up some or all of their rights. And some of those rights are delegable to a guardian and some of them are not. The person just loses them and no one can exercise them, such as the right to marry. So it's called a limited guardianship if they've only had some rights removed. It's called a plenary guardianship if they've had all of their rights removed. So and the order appointing the guardian will list out specifically which rights have been removed, which ones are delegated to the guardian, and which ones are not delegated to the guardian.
Can I just interject for a second?
Mhm.
Just from handling some cases when I was with DRF, familiarize yourself with the type of document you want to be looking for. Some folks will give you, for example, a report of the guardian. That's not the document you want. You want the document that specifically explains what rights are retained by the client, if any. I also want to give a plug for rereading Rule 4-1.14 because it is very specific that in Florida, anyway, a lawyer is not required to seek guardianship. They can in certain circumstances, but that does vary from other states. So be sure that you read that rule in its entirety and note that it does say that you are not, even if you think that the person has incapacity, you're not required to seek that guardianship for your client.
Thank you. Thanks for adding that. So I'm going to talk a little bit about guardian advocacy, and then I'll talk about how those kind of interplay with your interactions before moving on. So, guardian advocacy, similar to guardianship, you are going to have the one of the main differences is that in guardian advocacy, they have to retain at least one right. So there can never be a plenary guardian advocacy. So there are two types of guardian advocacy. One is in Section 393, and it applies to individuals with developmental disabilities as defined in Section 393. And then the second type is a mental health guardian advocacy, which is found in Section 394. The mental health guardian advocacy is far more limited to just decisions surrounding kind of a current mental health situation, whereas the 393 developmental disability guardian advocacy is much more like a plenary guardianship. It can last forever and isn't limited to only about the disability. So in with guardian advocacy, another big difference between that and guardianship is guardian advocacy does not require a finding of incapacity. All it requires is proof that the person has a developmental disability. The examining committee process that you may have heard of with guardianship is not required. It's a quicker, less expensive way to get to guardianship, but it also provides fewer due process rights to the person whose rights are at risk of being taken away. They don't get that examining committee. They don't, like I said, there doesn't have to be a finding of incapacity. So in some ways it's cheaper and easier, but in other ways it's less protective and kind of there are more pitfalls through guardian advocacy. So when you have a client that comes in to to your organization who is under guardianship or guardian advocacy, if the relevant rights are removed, the right to contract, the right to conduct business and that sort of thing, their rights relevant to the representation that they're seeking. If those rights have been removed, then their guardian or guardian advocate is going to be the legal decision maker. However, that said, you do not want to push out the person who's under guardianship or guardian advocacy from the case, from the decision-making process. Yes, there will be some people under guardianship and guardian advocacy who are totally unable to participate in their legal representation. Maybe they're in a coma, something like that. But, generally folks with guardianships and guardian advocacies, they're still active participants in their own life. They are able to understand, what's going on around them. They certainly have preferences about how their life is going to be led. And taking those preferences into account is not only like the right thing to do, it's also clear under the ethics rules that you should be doing that. So just because the guardian or the guardian advocate is the final decision maker, in the guardianship statutes all throughout and the guardian advocacy statutes, it requires the guardian to take into account, the ward's preferences. So you should be understanding what the ward's preferences are in your representation of these individuals, ensuring that your guardian advocate is indeed making decisions in line with the ward's preferences. So, taking the time to include the person under guardianship or under guardian advocacy in conversations about important decisions about their case, the general direction, what kind of outcome they're looking for, their ultimate preferences is, ethically required and also, appropriate for those individuals.
And I think later in some slides, we'll talk about practical steps you can take, but just to put an idea in your mind, for example, if a person is subject to guardianship, you might still have them in the room with the guardian during whatever conversation. And then at the end of that conversation, ask them if they have questions, if they have anything specific they'd like to tell you about the things you've discussed, etc. Unless the person lacks all capacity, you want to do as much as you can to understand what they want and make sure that you have explained it in any way that is effective to help them understand the representation.
Right. Thank you. So the next couple things we're going to talk about are powers of attorney and supported decision-making agreements. So powers of attorney are generally, folks are generally familiar with them. It's a legal document that says, I'm the principal, you're the agent, I'm giving you the authority to act on my behalf, to, sign documents, to et cetera, et cetera. It has to be delineated in the agreement what authorities you're giving to them. There are powers of attorney that are durable and ones that are not durable. Durable means that the authority granted does not end if the person becomes incapacitated. But there is certain statutory language that is required to be there for it to be durable. It doesn't have to be exact words, but it does have to, in writing, indicate that it's meant to be durable. A limited power of attorney is gonna, you can just kind of grant like all the power I have that's delegable can be given to this other person. A limited power of attorney is going to be more specific, giving them, permission to do only certain things, transact, banking transactions, transfers of property, et cetera. So, a big difference here between what we were just talking about is that a power of attorney is concurrent authority. Guardianship and guardian advocacy, the person under guardianship loses their authority to make decisions. The other person is given that authority. With a power of attorney, we have concurrent authority. The principal can still make all their own decisions, do all their own transacting, but also the agent can as well. So again, like Katherine said, you want to read the power of attorney. You want to know whether it's durable or not. You want to read exactly what authorities were granted and what were not, in order to know who your decision maker is in any given circumstance. And then, so supported decision making is a type.
Do you mind if I interrupt you yet again to just say something about powers of attorney?
Yeah, go for it.
I assume folks are wondering, but not asking yet, what you do if your power of attorney, if the power of attorney is asking you to do something that you think is contrary to what your client would want.
I was gonna get there. Sorry.
No, I want to interrupt you then. Go ahead. I'll hold you to it.
I'll talk about these supported decision-making agreements because they're a type of power of attorney, and then I'll wrap it up. But so with supported decision-making agreements, they are a type of power of attorney. They are non-durable. They cannot be durable. It doesn't matter if you call them durable. They are not durable. Essentially what they are is they are an agreement between a person who might be at risk of losing their rights, a person who might be at risk of guardianship, and someone who's there to support them, to make their own decisions. And essentially, you just write out, the person who's the decision maker would be the person at risk of losing their rights. So the decision maker says, I want help making decisions about education and healthcare. And I'm naming my supporter, the person who's going to help me make these decisions. It's a written contract. The supporter agrees to be there on whatever level they're being asked to. And it also confers the ability for the supporter to communicate on behalf of the decision maker. They can get records on behalf of the decision maker, but they can't make decisions contrary to the decision maker. The decision maker remains, they retain all of their decision-making power. SDM agreements do not confer any decision-making power. What they do is in situations where a person who maybe is kind of on the edge and folks are like, I'm not sure they're able to make the best decisions and maybe we should be seeking guardianship, and where this SDM agreement can come in and provide just that one extra layer of comfort that they have support in understanding their options, understanding the pros and cons, and making informed choices. And we're going to get to it in a little bit, but there's a big difference between a person who makes questionable choices, maybe doesn't make the best choices all the time, versus a person who cannot make their own choices. And guardianship and guardian advocacy are really only appropriate for a person who cannot make decisions. So again, it's not concurrent decision making. It's not substitute decision making. It is the decision maker retains all authority, and the supporter just helps them understand what they're doing, can help them gather information to help inform their choice, and can help them communicate that choice. Go with them to the bank and help them make sure that they're communicating clearly what kind of account they want to open, etc. And so when you're looking at these types of agreements, again, you want to read them, you want to see what kind of authority is there. And again, it's not going to grant any substitute decision-making authority, but it can give you information about where you want to include a consultation with a supporter, or where they're able to be included in your conversations with your client. And this wraps into the ethics rules as far as privilege. So we're gonna Katherine has a slide later on the specific rule, but that conferral of the ability to have your supporter communicate decisions and gather information is important, as far as making sure that if that person's in the room with your client, you're not destroying any sort of privilege there. And
aren't you going to tell us why your beautiful picture is on this slide?
Oh, because Katherine put it on the slide. There's a podcast episode on our episode from a couple years ago, before the supported decision-making statute was passed, where I discussed the concept of supported decision-making and why we thought we needed it in Florida. There was a bill passed last year, and so it's been in effect for over a year now. And yeah, that's why my picture is on the slide. I did help promote that bill.
Kayla was a big part of getting that legislation passed. So if you have any questions about SDM, she's definitely the lady to talk to.
Yes, sure. So when you're talking about how this impacts your interactions with your clients, again, I explained a bit about communication and not destroying privilege, but when you have a power of attorney, especially a durable power of attorney, just because your agent can make decisions for your client, you should not be excluding your client from conversations about important decisions. You should absolutely be, yeah, your power of attorney can come in and sign those documents or whatever, but when you're talking about the direction of the case, when you're talking about whether or not to accept a settlement offer, when you're talking about, important decisions, like, you should not be relying only on the POA, even if they insist this is what your client would want. Call your client, speak to your client, make sure that is happening properly. If you don't believe that the agent is acting in accordance with what your client wants, that is a situation that you need to address. And I think we have slides on that later. And Katherine, sorry, you were going to say something and I was going to address it, and then I totally forgot what it was.
Oh, I think the thing to address is, what do you do practically? So the power of it. So let's assume that your client had or just has a power of attorney, but they still have capacity, and the power of attorney is trying to get you to do things that you don't think the client would want to do, but your client still has capacity. What would you do?
Right. So if my client has capacity and is saying, I don't want to move to that new nursing home, and the power of attorney is coming in saying, I'm ready to sign the paperwork, let's get them moved to that new nursing home. In the power of attorney statute, there are there are um, there are penalties for someone who does not accept a power of attorney. But you do not have to accept a power of attorney if you don't believe the power of attorney is acting within the law. The law does require them to act in the way that they believe that the principal would act. So if you have a principal with capacity saying, I don't want to move, then it is clear that the guardian is, or sorry, that the power of attorney, the agent, is acting improperly if they are doing something different than that. If you have a client who does not have capacity, there are times when you can kind of infer or understand generally what their wishes would be anyway. Maybe they've made statements in the past. Maybe they were seeking something specific before their incapacity happened, and you know that's what they wanted. So you can know whether the agent is acting in accordance with their wishes. Sometimes it's not as clear. And then if you find yourself in a situation where you're not sure that the agent is acting within the law, they're not acting according to the principal's preferences. Generally, at that point, you're going to need to go to a court to have a court deem whether or not that power of attorney is still valid. The court can invalidate a power of attorney if the agent is not following the law and not acting in accordance with the principal's wishes.
And I think the way that you practically do that is usually by finding a next friend, a sibling or a parent who knows about the client's best wishes prior to their incapacity. Now, this assumes this power of attorney is durable, right? And they can
Right.
file a petition to dissolve that power of attorney.
Right. Okay. So what happens if a client loses capacity? Again, you should still continue to maintain communication with your client to the best extent possible. There are times where communication is not possible. Like, they're in the ICU on a ventilator and are not conscious. But like I said, there are times when you can you can have information and know kind of generally what their preferences were prior to losing capacity. And again, like even if you're the words you're choosing, the level of kind of reading level that you're speaking at or writing at needs to change. Like that's on you to adjust to that, to have patience with their communication. And again, even if they're not the ultimate decision maker anymore at this point, their preferences are absolutely still relevant and important to understand, both in the context of a power of attorney or a guardianship or a guardian advocacy, but also just in the context of human decency. Yeah, use your knowledge about any knowledge that you can garner. Can you talk to friends and family? Can you talk to that neighbor they were really close to? It might take extra work to deal with a client in this situation to get the information you need, but that is our ethical duty in these situations.
Caitlin, we have a question in the Q&A, so it's kind of related to these topics, so I wanted to make sure to bring it up. I'm going to read it out loud for the benefit of the audience. The question is, referencing 744-3085, can a person with sufficient capacity petition voluntarily for a guardian advocacy even without a developmental disability as an alternative to plenary guardianship in situations where a plenary guardianship is cost prohibitive? Thank you.
Sorry, make sure I understand the question. They're asking whether a person with a developmental disability can seek guardianship instead of guardian advocacy.
I think the other way around. And in the event that guardianship is too costly, can they seek guardian advocacy?
Yeah, so and yes, you can seek guardian advocacy. Again, the only folks who are eligible to be put under guardian advocacy are folks who have a developmental disability as defined in Chapter 393, which is different than how it's defined in the federal statutes, et cetera. It's a list of 7 very specific diagnoses. So yes, that is possible. It ends up being a little less expensive because I believe the person petitioning is not required to have an attorney, and the proceedings are truncated. There's no examining committee, et cetera. So it is absolutely an option, but only again for those who fall into that list of 7 diagnoses that are listed in 393 as the definition of a developmental disability. Thank you. Hope that answered it. If not, let me know. I'll try again. Okay, so capacity. And Catherine, what slide are you coming back in on? Was it this one?
I think I'm not until explain the law, but
Okay, I apologize.
sorry.
I did not print my notes and I cannot see them, but okay, so on capacity, as an attorney, obviously it's understandable if you think your client might lack capacity. If especially if it's happening during the representation and there aren't, provisions in place already. If a person is already under guardianship or guardian advocacy, a court has already decided that they do not have capacity. It's not something that you need to try to figure out or determine. But you do need to know in what areas the court has said they don't lack capacity, because it's not an all or nothing. You can still be retained by a person who's under guardianship, depending on, which rights have been taken. You can still be retained by a person who's under guardian advocacy, depending on which rights were taken, which ones they retain. But we don't want to shy away from representing people with concerns about capacity, because these folks are often more vulnerable. Catherine listed kind of some of the outcomes that happen to people with disabilities in the beginning. These folks should have equal access to representation, just like anyone else.
I would just add to really keep in mind that mental illness does not mean lack of capacity.
Right.
People with mental illness of a variety of types have capacity, limited or not, and they can retain you. And I'll send to Jorge an article written by some folks who only represent people with diminished capacity about engaging in representation and contract issues related to representing people with diminished capacity.
Right. And again, there's slides later on where we talk about it a little more, but making bad decisions, making questionable decisions, and then not being able to make decisions are two very different things. We don't always agree with our clients the path they choose, but that doesn't necessarily mean that we're now obligated to go tell the court they need a guardianship. So Rule 4-1.14 addresses clients with diminished capacity. The lawyer must maintain a normal client-lawyer relationship as much as reasonably possible, and they must exhaust all other available remedies to protect the client before going to the court and seeking any sort of removal or infringement of their rights. This rule does allow attorneys to notify the court to file a petition to seek guardianship for their client if they believe that they're incapacitated and require that. But it is permissive, not mandatory. You do not have to do that. And we're going to keep talking about capacity, but this is the most relevant on-point rule.
And you want to be as conservative as possible, I think, in your application of your permissive options, and keep in mind that they might have negative impacts for your client. For example, if they're a parent of young children, and other considerations like that.
And they're likely to have negative impacts as far as your client's level of trust they have in you, whether they're willing to continue working with you. It's a very extreme move to make, and really should be very carefully considered before taking that option. So again, like we were just discussing, protective action, you are not required to seek a determination of incapacity or appointment of a guardian or guardian advocate. You're not required to do any of that, but if you reasonably believe that they do have diminished capacity, or that they are at risk of substantial physical, financial, or other harm, unless someone takes action, you may take reasonably necessary protective action. That might be seeking a guardianship or guardian advocacy. It might be consulting with other organizations who can get involved and help the client without having to remove their rights. Also, appointments of guardians ad litem. So you need to make reasonable efforts to exhaust any and all other available options before you try to seek removal of your client's rights. Seeking guardianship or guardian advocacy should always be a last resort because it is very extreme and something that we don't really talk about here and folks often don't talk about is it is not easy to get out of a guardianship or guardian advocacy. Even if the guardian agrees and says, yeah, no, they're good now, they've learned, gained capacity, things have changed, it still takes a lot of time, money, energy, lawyers. A family can't just say, okay, we're done, and the court signs off. That is not how it works. So it's a really extreme and very impactful decision that you're making, and it should really be a last resort. So
I can jump in here if you want, since I made this silly slide.
Go for it.
So in researching this topic, you might find that the guidance available is not super helpful. And if you've ever called the bar ethics hotline, you might know that they really sometimes avoid answering direct questions, especially on thorny topics like this one. And that's sort of what Caitlyn was just explaining, is there are sort of guidelines, and in our state at least, it is permissive, meaning you can go to a court and seek some sort of guardianship if you think the client needs it, but you don't have to. But the ethical guidance is just not super clear, right? You can go to the next slide. So I think you might want to keep in mind ways that you can continue to work with a client and explore their capacity. And a lot of these ideas came from Caitlyn, so I will give her the credit for this slide for sure. You want to validate what your client knows about things that are relevant to their representation. And the reason that it says space lasers is to remind me about a client I once had who I represented in a foreclosure that also happened to believe that her neighbor was listening to her with the use of space lasers. That, after discussion with her, didn't impact her understanding of what we were working on. She definitely had some mental health concerns, but she understood the issues involved. She was able to answer my questions. She was consistent about what she wanted. She was able to tell me relevant facts that upon verification were in fact true. So those are the things you want to explain, right? Can they tell you what they want? Can they tell you why they want it? Are those answers consistent over time? The facts that they give you, are they real? Can you verify them? Are they true things? And do their decisions and statements now line up with things that they stated in the past, whether you represented them before or there's some other way that you can determine that. Really, your client no client has to have a perfect understanding of the law, but people with diminished capacity, whether it's mental illness or something else, can have the ability to understand things, consider and reach conclusions about things that impact their life, right? You want to just ensure that your client understands the pros and cons, just like with any client, as you have explained them, and can tell you their direction about what they want. And as Caitlyn referred to, and I think she may have been actually talking about me, people make bad decisions all the time, right? They make mistakes. They want things you don't want. And you may not have seen this good but sad documentary that Frontline put together. They have the right to fail. They have the right to make the wrong choice. Now, there will be some times where you have to break with a client for a lot of reasons, but clients can want things that are bad for them, and they can decide that those things are more important to them than other things. If you haven't seen that documentary, you should watch it. It has a lot to do with the community integration that I was referring to earlier. Can you go to the next slide? So as we said, even people with diminished capacity can have the ability to understand, consider, and reach conclusions about things that impact them, right? So what can we do to increase the chances that we know what this client wants and that they can communicate with us in a way that furthers our representation of them? Well, you can be in an appropriate environment. So for example, if your client has, whether it's a hearing disability or some kind of other disability that impacts their ability to communicate with you in a crowded environment or a loud environment, you want to make sure that you're in whatever environment is most conducive to that conversation. So if that means it's just you and them and there's nobody else nearby and it's quiet, then you do that to ensure that you can communicate effectively with that person. Just a reminder to still maintain confidentiality. This refers back to if there's that third person in the room, to ensure that that person is in fact necessary for your representation, so that your client doesn't give up their right to privilege and have their information be confidential. Use plain language. I think if you go to webinars, you'll hear about that a lot. It applies to any client with disability or not. Avoid legalese. Use simple, direct language that your client is going to be able to really digest and understand. One of Caitlyn's excellent ideas is to break decisions down into steps. So while the legal problem may be large and complex, there are going to be a series of individual decisions that are going to lead up to the big decision at the end. So you can break those decisions down into steps. Do you like where you live, for example, might be the first question you ask in a housing case, so that you can help your client help you understand what it is that they want, what risks they're willing to take, what their ultimate goal is at the end of the day. And remember, and I say this a lot, and I think I learned it from my parents, you are a counselor at law. You are not just a blank slate hearing what your client tells you. You can give them, and you should give them, and you must give them your advice, right? Whether they like it or follow it is different. But you are a counselor at law. You must give your client your advice about the pros and cons, the risks and benefits, the likelihood of success, which are sometimes difficult conversations to have. Jorge, did you want to pop in?
Yeah, we have a question in the Q&A that I believe was related to the previous slide, and I'm going to read it out loud. It's based on the last slide. An attorney is not required to seek determination of capacity, but client comes in for services and seems reasonable. The attorney may provide services. The attorney doesn't look into medical history, but the client had some previous incidents that make the family doubt about capacity and may argue with the attorney after a document has been executed. How can a lawyer guard himself or herself in these cases?
Caitlyn has raised her hand.
Happily. So the law presumes that every adult has capacity unless a court has said you do not have capacity, your rights are being removed. So an attorney who, if there's no guardianship or no guardian advocacy, nothing taking away this person's rights, a lawyer who takes them at face value, who interacts with them, who doesn't have any sort of indication that they do lack capacity is, fine to go ahead with their representation. And if the family doesn't like it, we deal with this all of the time, where the family thinks they're making bad choices, they're making dangerous choices. They'd rather them stay at home and not move in with that boyfriend, etc. The family is not your client. What they choose to do is on them. If they want to file and go seek guardianship, have at it. But that's really, your client is your client. Your ethical obligations are to your client. Your representation should be focused on your client and what they want. And unless and until a court says that an adult's rights are being removed, all their rights are intact, and you are safe to move forward with that knowledge.
And I think practically the things that you can do and really would do with any client are ask them the questions we talked about before, right? What do you want? Why do you want it? Tell me about your goals. We'll break down this problem into steps, and you tell me what you want each step of the way so I can understand how to achieve that goal, right? When I did more disability focused work, there is a tension, because if we have children, they will eventually hopefully grow up, right? And they will do things we don't like. And sometimes parents of formerly minor children will not like the decisions that their now adult child is making. And they will do as the questioner said and say, that's not right for them, right? But it's your client's life and it's their right. And they can make the decisions that they think are best for them with your counsel, right? You can certainly tell them, if you do this thing you want to do, this bad thing is likely to happen. But that doesn't mean that they don't get the ultimate decision making, whether it's with you or some other attorney or no attorney.
Yeah, relating to this slide and that question, I have a slightly more subtle example than Catherine's space laser example that was posed to me actually when I gave a presentation similar to this one by a legal aid attorney. And if you're here, hi, thank you for the example. But speaking about, at the bottom of the slide, you see the phrase dignity of risk. We all learn from our mistakes. That's something we all do. When families are expressing dismay at the decisions their family members are making, You know, we're talking about the dignity of risk, and this person is an adult, and, you know, just like I get to choose whether or not I default on my student loans, they get to choose whether or not they're going to pay their car registration. You know, like we enjoy that dignity as adults. But there was an example brought to me by a legal aid attorney. They were representing a woman, and she was unhoused, I believe, and this attorney had identified this great housing option for them. The person was unhoused and staying in Tallahassee, you know, in a metropolitan area, well, relatively metropolitan. But, you know, in the city, you know, close to stores and shelters and, you know, food pantries, etc. This attorney had identified a housing option for them in one of our kind of outlying counties in our circuit. It's much more rural. The housing option was great, clean, affordable, etc. The client said, "Thank you, but no thank you. I'm not moving there." And the attorney was worried that this meant that their client had was lacking capacity, and you know, did not understand this decision. How can you choose to remain unhoused to live on the streets when here's a housing option that's great and affordable and would work for you? And you know, the attorney came to understand that she was making calculations based on her own life and her own preferences. It was more important to her to be near resources and near other individuals who were able to provide her day-to-day assistance and, you know, companionship and all of that than it was to live in four walls with a ceiling. So, you know, after the presentation and having a discussion with that attorney, they went from thinking they needed to seek a guardianship for this woman because she's making irrational choices and therefore must not have capacity, to then understanding that, you know, she needed to see this from the client's perspective. The client was absolutely making rational decisions. It was just based on preferences that were different than the attorney's own preferences. So like I said, a little bit more subtle than the space lasers, but you know, it really is about, you know, we don't like all of our clients' choices. That is, I think every attorney has had experiences with not liking the choice their client made. However, it's until it's no longer their choice because they've had their rights removed, it's their choice.
And I really, really encourage you to not only read Rule 4-1.14, but to read the entirety of the comment. If you haven't read it before, you might be surprised by how strongly it says essentially what Caitlyn just said, which is your client has the right to make the decision until somebody tells them, the court tells them that they don't have the right. And you know, you're your client's lawyer. And if the family's upset, I mean, unless your client wants you to talk to them, you don't even have to talk to them. They're not your client. You know, your job is to be your client's representative and to carry out their, you know, their wishes within the guidelines that we all follow. But that doesn't mean that they're going to be the decisions that you like, or that you think are the smartest choices. You know, but that's life for every person, right? Just to give one more example of something you can do to increase the chances that you can have effective communication and representation with your client. With some people's disabilities, it may vary by the time of day that you talk with them. So, for example, if they're better in the morning, and you know, you don't have to have capacity all of the time. You have to have capacity when the thing is happening, right? So, if this person is not able to effectively communicate with you, you know, after 2 o'clock, then have your meetings with them in the morning. And obviously, like with any meeting, you'll document it, what you talked about, you know, that they clearly expressed their wishes, what they were, etc. Just keep in mind, and I think that's what a lot of this presentation is about, is, you know, this is your client's life. It's not their power of attorney's life, right? I think it is really tempting sometimes, especially working with people with disabilities, that make it really challenging to represent them. And I don't think Caitlyn or I would say that representing lots of clients is challenging, but representing some people with particular disabilities, specifically, you know, mental illness, for example, can be really difficult, right? Nobody likes getting yelled at on the phone or other things like that. But you know, you still, if you're representing that person, you still have all of the same obligations to them that you did to any other client. You can switch the slide. So to some less heavy stuff that's just more practical in nature. So we've talked so far about like just, you know, representing someone with disabilities. But I want you to also keep in mind that you need to make sure that your written materials are accessible. And when I say accessible, I mean that in the broadest meaning of the term, meaning can your client understand it, learn from it, you know, get what you're trying to tell them. But I would like to suggest that you keep in mind that all of your written material should go through this checklist, because you never know who in your audience has a disability that's going to impact their ability to understand what you've told them, whether it's in this room, right? I don't have any idea who any of you folks are, or in a work meeting, or anywhere else, right? You want to use plain language, so avoiding as much as you can anyway, jargon. More practical even, you want to have clear headings in your documents and your PowerPoints. You may have noticed that as we've gone through this presentation, there has been a heading at the top. And then, for example, on this slide, it says 1 of 2, right? Well, why is that? Well, people who are using what's called a screen reader, which you may or may not be familiar with, so people who have a vision impairment or are totally blind, rely on a device to read to them what is on the screen. It's hard enough to follow a presentation when you're listening, right? And someone's talking at you. It's even harder when it's being read to you by the screen reader. So these indications, 1 of 2, let that person know that we're on the same topic as we will be on the next slide, which makes it much easier for them to understand and digest the information that you're giving them. Similarly, you want to have page numbers so people can stay organized. The screen reader will read those out and help them make sure that they're following things in order. You want to have 14-point font in Word and at least 24-point font in your PowerPoint, and that is for maximum visibility. Similarly, that's why this presentation is on a white background. It doesn't have to be white, but you want to aim for a light background and dark text that is most visible for a person who has any kind of vision impairment. You also want to have a readable font. There are a number of them. Essentially, you want to avoid anything that approaches looking like cursive. So avoid italics. You can Google which fonts are most accessible and make sure that all of your writing is in those fonts, even if we might prefer some more flowery font. You can go to the next slide. Oh, I forgot to mention, you should visit the website of the National Disability Rights Network, which is NDRN, which is the parent organization of the PNAs, like that Caitlyn works for. They have a ton of information about all things disability, including how to make your materials most accessible. So again, that's National Disability Rights Network. If you want to learn about representing people with disabilities, it's a really good place to start. So we've already talked about the color of your PowerPoint presentation. Please do use alt text. So you might have seen some totally hilarious images in this PowerPoint. If you click on each one of them, there is a written description of what it is. So for example, if it's Cartman, it tells you that it is Cartman from South Park and what Cartman is saying. The reason is if a person cannot see your slide, they do not get the benefit of whatever that image is. The screen reader will read the alt text to them. Similarly, if you're using an image and unlike Cartman, it is actually relevant to what you're talking about, you want to describe it while you're talking about that information, because you have to keep in mind that not everyone is able to see and digest the thing that you're referring to, right? You want to keep your slides short. Remember that screen reader is reading out everything. And I'll get to the chat, not what's in the chat, but the existence of the chat in a moment. But you want to keep the words on your slides as short as you can, which I have failed to do in this PowerPoint, but I try to be more succinct, both because it keeps you from reading, which is super boring, right, when people read presentations to you, but it also helps people who are using screen readers. PowerPoint and Word have an accessibility checker. You can just run it, and it will highlight the more obvious errors that you have made in your document. And if you're using a PDF, you want to run what's called OCR, which isn't perfect and won't always make your PowerPoint accessible, but it's a good first step for accessibility. When you try to Control F in a PDF and it doesn't work, you can run OCR, and sometimes that will assist in being able to actually decipher all of that text using the computer. Caitlin?
Yeah, I was just going to add a couple of the resources. There's I believe it's called the Hemingway app. If you just Google that, it should come up, and that helps you. You can run text through it, and it will tell you whether it's plain language or not. And it'll highlight, these phrases might be more difficult to understand. Here's where you should make changes to achieve plain language. There are also, I'm failing to come up with a name right now, but there are also websites that will check your materials or even your website for that contrast, whether the background is contrasting enough with the text and images to have it be visible to people with low vision. There are ton of accessibility kind of review tools online that you can access almost generally for free.
I want to make sort of an umbrella point here, and Caitlin, if you have any thoughts about it, chime in. But you might be thinking, well, my office doesn't have any person with a disability in it, or I don't think my audience has people with disabilities. But I want you to think back to the percentage of the United States population that has a disability and the number of lawyers or members of any sort of white collar profession that have a disability. And remember that if we don't make intentional steps to make all of the things that we do accessible to all people, that we are part of that barrier to those people engaging in what we're doing. So even if you think that your audience is not a person who needs an accessible whatever it is, I suggest that you do it anyway.
Well, and perhaps your audience isn't that because they can't access your materials, and perhaps your audience and client base would grow if they could access your materials.
Right. So I think generally keeping in mind, the ability of all people to access and understand what you're doing is something you should always keep in mind. So on that point, and this is something that I definitely did not know before I got to DRF, and I think Caitlin maybe not either, is if you're in a meeting, say your name every time you talk. Hey, this is Katherine, words, right? If a person can't see who you are, right, or for whatever reason doesn't know who you are before you talk, they're going to lose important context about who's talking. So you should just try to make that a habit, especially in a large gathering. The reason I was talking about the chat is a lot of folks use chat. I think maybe it's less intimidating than talking, or you don't want to interrupt, right? You want to get your thought out. Just keep in mind that the screen reader reads those things. So if you're in like a staff meeting and everyone's saying, hello, 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 some person using a screen reader is hearing those words over the thing they're trying to listen to. So, if you're in charge of that kind of stuff for your organization about those rules and policies, you should keep that in mind. When we don't have people with a variety of disabilities in the room, we might not know that that's happening or not know that it's a problem, right? Similarly, if you're working with a client who uses an interpreter of any kind, talk a lot slower than I do. I talk way too fast, right? So when I'm working with an interpreter, I have to like make myself 9 notes, right? And the interpreter's forever stopping me, just like the court reporter. Quit talking so fast, right? That's really important because you want to make sure that the interpreter can understand what you said, that the client has time to digest it. So try to act like you're in a deposition and you want that court reporter to get everything that you said, which is really challenging for some of us who talk way too fast. If you're referring to some document or material in a meeting, you don't want to point at it, right? This document, you want to specifically identify, like you're in court, I am referring to the letter I sent to Bob on September the 1st, so that people know what you're talking about during that meeting. And keep in mind all the things we talked about before about making sure any materials you distribute prior to a meeting, any presentations that you distribute are all accessible. Like I said, this applies to clients, coworkers, etc. If we don't make an effort to ensure that our materials are accessible, people won't be able to access them and might not even try, right? Do the next slide. So I think overall, you want to respect your client and you want to do your best. Your work is important. And like I said at the very beginning, you can help your clients with disabilities stay integrated in their community, which has economic benefits, health benefits, etc. I meant to mention on, I think, slide 3, there's an excellent video that you can get on DRF's website or NDRN's website about the Olmstead decision. If you're not familiar with the Olmstead decision, you absolutely should be. And that video is brief, and it will introduce you, if you're not already familiar, with the concept of community integration, why it is essential, and how your work assists in ensuring community integration. Remember, people with disabilities are more likely to be poor, which means that legal aid attorneys are more likely than the private bar to encounter clients with disabilities. You can be the difference between your client living in the community and having to live in an institution. And I think that is just work. So I don't know if there are any questions or standing ovation.
So we were answering questions as they were coming in. So if anybody wants to raise their hand and come off mute, we can do that as well. I've been compiling these resources that both Catherine and Caitlin have mentioned. So I will include a bunch of these links in the materials as well when I send them out via email. I see a hand raised. Let me see if I can. I know that when people raise their hand, sometimes it gets lowered immediately. It may have been inadvertent, so I'll try to find if anybody has any hands raised. While people ask questions, I'm going to go ahead and share the CLE code and some other links that I have compiled. I do see a comment here for a standing ovation from Christy. Thank you both for such a great presentation. I learned a lot.
That doesn't count, Christy. Christy's a friend. We won't discount her entirely. Thank you, though.
All right, so I'm going to drop the CLE code into the chat and I will read it out loud. And it will go out via email as well, and we will share the CLE code in the YouTube description as well. So, as I said earlier, this one was approved for 1.5 CLE credits. It was also approved for 0.5 ethics and 0.5 technology credits. The code is 2507332N. So I will send it out via email and in the YouTube description as well. I did want to share there were multiple resources mentioned, in particular from Disability Rights Florida. In the materials, I will include a bunch of links to their website, but also to all of their social media accounts. But in their website in particular, look at the newsletter. You can sign up for the newsletter. They have a podcast, they have webinars, they have videos. I also found the Olmsted video that Catherine mentioned, so I'll have a link specifically for that video as well to share with everybody. So make sure you look at those websites, bookmark them, sign for the newsletters, and follow them on social media. So
I just want to give one more plug for Disability Rights Florida, because I've noticed over time that folks have it's a challenge to start representing people with disabilities, especially profound disabilities that impact their ability to work with a lawyer. So if you have a client with a disability and you have questions, you're having difficulty, I would really encourage you to reach out to your PNA, which in Florida is Disability Rights Florida, not only to get tips, but possibly for co-counseling, depending on their the capacity of Disability Rights Florida and the issue, to assist you in that representation, because they are the expert. That's their role.
Yeah, I happily if an attorney calls into our intake and they have a question, I happily take those calls, give you a call back, answer what I can, offer whatever assistance I can. That's what we're here for. It's, part of our job. And I just wanted to say thanks to everyone for coming and for being interested. And, at the beginning, one of my favorite parts of this presentation is at the very beginning, Catherine gets to talk about it, but it's the bit about using euphemisms and not being afraid to ask. This slide up here at the last slide says represent your client and do your best. That's the expectation. Do your best. Nobody's perfect. Mistakes are often made. But if you are speaking to your client, asking their preferences, and then honoring those preferences like that's the expectation. That's what you want to do. Different clients have different preferences. But asking a person about, the cane they're using, or if they need help opening a door, they're not learning for the first time that they are disabled. They know they're disabled. It is fine. Just ask.
Yeah, it does take a little bit of time to get over your own self-consciousness, but just you got to put yourself out there. That's the only way to do it.
Right. I don't see any new questions. I do see a lot of thank yous and appreciation in the chat. I totally agree. Great presentation. So thank you, Catherine and Caitlin, for an amazing presentation. As always, I will be sending out an email, or soon we'll be sending out an email with all this information. I've always tried to include in the YouTube description kind of a cheat code I've been adding the materials and any other resources that we discussed during these presentations. So I've also included contact information for both Caitlin and Catherine. So if you have any questions that may come up afterwards, feel free to email them or email me, and I'll try to connect you with both Caitlin and Catherine. Oh, see, I have a celebrity name now for both of you. I didn't think about it that way. So, but yeah, thank you everybody for joining. I guess we're a little bit early, but everybody has 15 minutes back for their day, and we have a long weekend ahead. So I guess that's great news. So thank you everybody for joining us, and have a great rest of your day.
Bye, guys.
Thank you.